What is an international transfer? Under the GDPR, an international transfer occurs when personal data is sent from the EU or EEA to a country outside the EEA, or accessed from outside the EEA, even if the data remains physically stored within the EU. This means that international transfers are not limited to physically sending files abroad. Remote access by employees, vendors, or service providers located outside the EEA can also qualify as a transfer. Why does GDPR regulate international transfers? The GDPR was designed to protect individuals' personal data and fundamental rights. However, not all countries offer the same level of data protection as the EU. Without safeguards, transferring data to countries with weaker privacy laws could expose individuals to unauthorized surveillance, data misuse or exploitation, limited legal remedies if something goes wrong. The general rule for international transfers. GDPR allows international transfers only if the transfer complies with GDPR principles and one of the approved transfer mechanisms under Chapter 5 of the GDPR is in place. These mechanisms ensure that personal data remains protected even after it leaves the EEA. Transfer Mechanism 1. Adequacy decisions. The simplest way to lawfully transfer personal data internationally is through an adequacy decision. An adequacy decision is made by the European Commission and confirms that a non-EEA country provides an adequate level of data protection comparable to the EU. Examples of countries with adequacy decisions include Japan, Canada, commercial organizations, Switzerland, United Kingdom. When transferring data to a country with an adequacy decision, no additional safeguards are required. Transfers can take place as freely as within the EU. Transfer Mechanism 2. Appropriate safeguards. If no adequacy decision exists, organizations must rely on appropriate safeguards to protect personal data. Standard Contractual Clauses, SCCs. Standard contractual clauses are pre-approved legal agreements issued by the European Commission. They bind the data exporter and importer to GDPR-level protections. Grant enforceable rights to data subjects, are the most commonly used transfer mechanism. Binding corporate rules, BCRs. Binding corporate rules apply to multinational organizations transferring data within their corporate group. They are internal policies approved by a supervisory authority, apply to all group entities worldwide, require strong governance, training, and enforcement mechanisms. While complex and time-consuming to implement, BCRs offer a long-term solution for large organizations. Transfer Impact Assessments, TIAs. Following key court decisions, organizations using SCCs or similar safeguards must conduct a Transfer Impact Assessment. TIA evaluates the nature of the personal data being transferred, the purpose of the transfer, the legal environment of the destination country, potential access by public authorities, additional technical or organizational safeguards. If risks cannot be adequately mitigated, the transfer must not proceed. Transfer Mechanism 3. Derogations for specific situations. In limited cases, GDPR allows international transfers without adequacy decisions or safeguards through derogations. These include explicit consent from the data subject, transfers necessary for contract performance, transfers required for important public interest reasons, transfers necessary for legal claims. Derogations are exceptions, not the rule, and should only be used occasionally, not for regular or large-scale transfers. Responsibilities of organizations. Organizations involved in international data transfers must identify and document all international transfers, select the appropriate transfer mechanism, conduct risk assessments where required, implement technical and organizational security measures, inform data subjects about international transfers in privacy notices, monitor changes in law and guidance. Failure to manage international transfers properly can result in significant fines and reputational damage. Consequences of non-compliance. Unlawful international transfers are a serious GDPR violation and can lead to administrative fines of up to €20 million or 4% of global annual turnover. Orders to suspend or stop data transfers. Legal action by data subjects. Loss of customer trust and business credibility. This concludes Module 7, International Transfers of the GDPR Training by Complico. Understanding and managing international data transfers is critical in today's interconnected world. By applying the correct safeguards and maintaining accountability, organizations can operate globally while respecting individuals' data protection rights. Thank you for completing this module.